Good evening, and welcome to our Dossiter Health Ethics Seminar on Government Powers and COVID-19, Balancing Public Health and Civil Liberties in a Public Health Emergency. Tonight we are joined by Tracy Bailey. Tracy is a core member of the John Dossiter Health Ethics Center. She has decades of experience in the area of health law, policy, and ethics. She's practiced in both public and private sectors, and has also taught and published around contemporary issues in health law and public health law and ethics. Finally, Tracy has served on numerous policy working groups and clinical and research ethics committees.
Thank you, Michael. I'm just going to, I hope that my slideshow is going to work here. It looks like it's working. Michael, please tell me if it's not at any point. Just a few opening comments. First of all, as Michael alluded to, I've worked in the health area as a lawyer for many, many years, and just have a few kind of things that I wanted to run through quickly before I jump into my comments on government powers during a public health emergency. But just to make it clear, I'm not speaking on behalf of any other persons or organizations. I am currently, as a result of the virus, unemployed, so I have no clients or anything like that I am currently serving. And so these really are my own thoughts and comments with respect to this issue. I don't have any conflicts of interest to declare. I do want to stress that this is a public education talk, and what I am providing this evening is not legal advice. It's very important for anyone out there that actually needs legal advice for this or any other health matter that they seek that legal advice from their legal counsel. Even if I was in a position to try to provide such, which I'm not, I cannot. It also wouldn't be appropriate, and it wouldn't be helpful to those of you listening who might actually need some legal advice. To give proper legal advice, a lawyer really needs to understand all of the facts of a particular situation and do some thoughtful analysis about that. So I hope that what I have to say tonight is informative and educational, but again, it's not legal advice that should govern anybody or that anybody should rely on. I'm a long-standing affiliate with the John Dossiter Health Ethics Center, and I do want to say I really think it's a fantastic center. I think that whether we're in times of crisis like we are today or during more so-called normal times, it's important to have places where we can ethically reflect, whether that be on the law or all sorts of other policy or societal issues and matters. And I also want to say before I start that the intent of my talk today is just to outline some, like I say, bits of information that I hope people will find helpful and informative. It's not intended as a critique, and quite the opposite. It's provided with the intent of, being in solidarity with all the many, many people who, unlike myself at the moment, are actively engaged in managing this public health emergency. And I want to acknowledge and thank everyone from government officials, public health officials, healthcare and other essential workers, my former justice colleagues who I miss, and many, many, many others of the enormous efforts that are being poured into addressing this public health emergency. So that's the spirit in which my talk is offered up tonight. First of all, obviously we are in the midst of, everybody has heard the word pandemic used with respect to COVID-19. And many of you may already be aware of this, but when we're using the term pandemic, and one of the things I'll touch on briefly tonight will maybe make this important for me to just point out briefly, we're talking about a greater number of cases of infectious diseases than we would normally see, but on an international scale, versus an epidemic, where we might have, for example, in part of the province of Alberta or all of the province of Alberta, a greater number of cases of an infectious disease than we would normally see, but it's more limited to a localized area. So what we've got here is actually a pandemic of COVID-19. And we've also seen, both worldwide and in every province and territory in Canada, different states of emergency declared. So for example, across Canada, we have had every province or territory declare a state of emergency. Some of those provinces and territories have declared, as Alberta has, a state of public health emergency. Other provinces have used more general emergency management legislation to declare a more general state of emergency. But across the country, without exception, those declarations have been made. And that is important and gets us into the subject of what we're going to talk about tonight, because it opens up for government and other officials some extraordinary powers to be used to manage emergencies. We saw the earliest one in Quebec being declared by, the earliest one in Canada being declared on March 12th by Quebec. And by March 22nd, Nova Scotia was the last province or territory to declare a public health emergency. Alberta, BC, and Ontario all made such declarations on March 17th. So tonight, as I say, we're going to talk a little bit about, during such a state, what powers and duties does a government have? What limits exist on those powers? And here's just a little bit of a roadmap of specifically where or what I'm intending to cover over the next duration of the talk before we get into questions and discussion. So very, very briefly, I'll try to set out a bit of the larger context, and I'll talk very briefly about governmental powers at different levels, so internationally, federally, provincially, municipally. But the main focus of my talk this evening will be on Alberta and on its Public Health Act. And essentially the reason I'm doing that is it's having the most direct impact on Albertans, and it's just the most relevant in terms of our lives and ethical reflection and legal reflection in the province today. So I will be focusing on, under Alberta's Public Health Act, on what are the public health powers, duties, and safeguards in normal times. So I'm going to begin with that just to try to set some context, some lay of the land before we jump into public health emergency powers. So in other words, when we're not in the midst of a public health emergency, what powers and duties do public health officials have to manage infectious disease in our province? I'm going to talk a bit about how a public health emergency is declared and how long it can last. We'll then cover what extraordinary powers exist during a public health emergency. Then we'll move on to a bit about how those powers have recently been enhanced here in Alberta by the government, how those powers have been exercised, and then end just with some quick reflections and time for discussion and questions. And given this is part of the Doster's Pandemic Ethics series, other people have already spoken to this in previous Doster lectures in this series, and that can speak to it much more eloquently than I can. But I did want to briefly at least make a few comments about distinctions between public health ethics in the law versus ethical principles and legal principles that we rely on if we're looking at other aspects of the healthcare system or the delivery of healthcare services, etc. When we're focusing on public health, we are focusing on population health, the health of one or more populations of people as opposed to the health of the individual. So that is where the focus and emphasis is. Our public health laws have extraordinary powers even during normal times. And those extraordinary powers are based on the ethical judgment call that has been incorporated into law, that sometimes if the risk of an individual's behavior could threaten the health of the population, we are justified in limiting or suspending normal rights and freedoms to address that. In one typical example, and I'll come back to this example this evening, is the ability, under certain conditions under public health legislation, to force treatment without a person's consent in certain circumstances. Normally, in the rest of the realm of health services, we would not, for example, ever force treatment on a competent adult. We would say it's their decision whether they're going to accept treatment that's proposed or not. But if certain criteria are met under public health legislation, that is not the case. Persons, including competent adults, can be forced to undergo treatment in certain circumstances. And we'll be talking a little bit more about those details. So very briefly, what is the more general legal landscape? I'm sure you've all been watching the news. Some commentary about international aspects of this. Canada is a member of the World Health Organization. Canada is a signatory to a number of international health regulations. And so definitely that is part of this landscape. We also have federal legislation, and that's federal legislation that applies generally in the public health area, such as our Federal Quarantine Act, our Public Health Agency of Canada Act, our Department of Health Act. We also have federal legislation that kicks in or can kick in if the federal government declares an emergency. For example, the Federal Emergencies Act, and there has been some commentary in the news lately about the federal government considering whether or not it would be appropriate to declare an emergency under that legislation. Generally speaking, that's only done if provinces give some indication that they're not up to managing the emergency on their own, or if some overriding, there's some overriding national need to coordinate certain things. And this version of the Emergencies Act, there has never been an emergency declared under it. The previous iteration of this legislation was the War Measures Act, which was used, I believe, in 1970 by Pierre Trudeau, our Prime Minister then. But so it's legislation that is not at all routinely used. But those are some examples of some of the relevant federal legislation. Then, of course, our provincial territorial legislation, which I'll be focusing on. But finally, important to remember that the authority of municipal governments also comes into play. And as an Alberta example, you may have seen, in addition to many of the provincial orders and so on that have been issued to deal with this emergency, we've seen city councils taking certain measures. So in the city of Edmonton, for example, a measure was taken so that if you could normally take your dog to an off-leash area and let it off-leash, you could no longer do that. You can no longer do that at this time. And that was a measure that the city took, and that wasn't applicable across the province. So to provincial legislation, the focus of our talk today, every province and territory in Canada has public health legislation and emergency management legislation. And just a few key points to keep in mind as we have this discussion or we read reports of different measures being taken in the news, is that even though every province and territory has legislation such as this, there are many differences between the legislative schemes in each province and territory. Every province and territory has approached these issues in a slightly different way. And so one cannot assume if they see the government of BC taking a certain step, for example, that the government of Ontario could take the same step or would even need to take the same step depending on the law framework in their province. So a number of differences, and it's just important to keep in mind that we're not necessarily comparing apples with apples. But of course, some key similarities exist between that legislation across the country. So for example, all of those pieces of public health legislation provide the power to appoint public health officials with certain powers under the Act. So for example, I've got MOH, the abbreviation MOH. When you see MOH in these slides, I'm referring to medical officers of health. Medical officers of health are all physicians, and they are appointed in Alberta, mostly by the Regional Health Authority, Alberta Health Services, some of them appointed by government. But there's provision in all of this legislation to provide those public health officials and invest them with certain powers. The other abbreviation you'll see here is EO. That refers, at least in Alberta, our Alberta legislation, to public health officials called executive officers. All medical officers of health are executive officers, but executive officers aren't necessarily medical officers of health, but they are public health officials that we'll touch on a bit later about some of their powers under our public health legislation. And all of this public health legislation does deal with the powers and duties to contain the spread of infectious disease. So those are some key differences and some key similarities. So as I mentioned earlier, unlike most other law and ethical principles that apply in the area of healthcare, powers under public health legislation can be quite extreme, and they include powers, for example, to detain and compel the assessment of a person to see whether they are infectious with a communicable disease. They include powers to treat a person. And so, for example, a person who has active tuberculosis, it's possible that they would be subject to orders requiring them to go through an examination, treatment, etc., and perhaps be detained in a facility. It's important to know, though, about some of the unwritten rules and written rules that put quite severe restrictions or limits on these huge powers. So the first is not necessarily written into public health legislation across the country, but at least an unwritten law or understanding across the country, I think it's fair to say, is that public health powers should only be used when needed. So while they're in existence in legislation, and they're quite significant powers, they're used very rarely and only as necessary. So we wouldn't begin, for example, if we had a person with active TB, by having a medical officer's health starting point wouldn't be ordering them to quarantine themselves if they were suspected to be infected, or ordering them to isolate themselves if that infection had been confirmed, until they tried less intrusive means. So almost always that would begin with education, with counseling, with the offering of any supports needed. And an order forcing somebody to be detained, treated, etc., without their consent would only be used as a last step. It's important to note that in the challenges to public health orders to date, Canadian courts have been very deferential to orders made by public health officials. But I suspect that one of the reasons that they have is that they're used very deferentially. They're used only when needed. So that would be what I call the unwritten law of public health powers. But if you look, for example, to Alberta's Public Health Act, there are also explicit limits on these powers. So in our Alberta legislation, a person with active tuberculosis, for example, can only be subject to an order to quarantine or to isolate if they are what the Act calls recalcitrant, which means they refuse to follow the advice and recommendations that have been made to them by their physician or other treating healthcare professional. The orders can also only be used with respect to specified diseases. And the list of the specified diseases for such quarantine and isolation orders is an extremely short list. It includes diseases such as SARS, pandemic influenza, tuberculosis, but these orders cannot be applied with respect to any infectious disease. And that makes sense given the significance of the powers, that it would be a disease that has been considered by public health experts to pose significant risk to others if it's left unchecked. These orders have to be person-specific, whether with respect to quarantine or isolation, and that's another limit that the legislation places on these orders. And the Act also provides a person subject to an order to a right to appeal on very short notice to the courts. So it's one of the places in the Act where we see a right of appeal tied to the exercise of an extreme power. So we've got those built-in limits on the power within the Act. Oh, there we go. So if you were an individual that had been subject to an order, for example, for quarantine or isolation, that individual with active tuberculosis, and you wish to appeal or you wish to challenge that order, one of the questions is, what are the limits on the use of such governmental powers and what could be done? So often, as in our Public Health Act in Alberta, there's an appeal mechanism built in, or other options for court review, judicial review, to determine issues, and I've listed some of the key ones on this slide. So the first one would be, was there any legal authority to use the power? And that would be an examination or look at the law or legislation to see if there was actually authority to do what was done. So for example, to issue a certain type of order. A related but a bit of a different question is, was the power used appropriately? So if that order was issued, was it issued with all of the criteria that the act required having been met, for example? And the second main things that I've outlined here, it relates to the Constitution. Was the law or the action taken under the law constitutional? So for example, did the government have the power to create the law in the first place? And we'll talk in a moment about how our Constitution sets out things that the federal government can pass laws about, things that the provincial government can pass law about. So that can be part of the examination. Did the government that passed the law actually have the jurisdiction or the authority to make the law in the first place? And finally, one key way that laws can be challenged is to see whether they violated a constitutional right or freedom set out in part of our Constitution, the Charter of Rights and Freedoms. And if so, was that breach of that right or freedom justified? So I'm going to start with the first part of the Constitution I mentioned, that we often talk about the division of powers. This is our Constitution Act of 1867, which set out what can the federal government make laws about, what can the provincial government make laws about. And I'm not a constitutional law expert, but I can say that the jurisdiction with respect to health is very mixed. And it's important to think back to why that would be the case. Back in 1867, during the time of Confederation, we didn't have a healthcare system that looked anything like our modern day healthcare system. And the role of government in the provision of healthcare services would have been extremely limited. So the things that were set out in that Constitution Act of 1867 give us some guidance, and the courts in interpreting it have given us a lot more guidance. But generally speaking, I think it's fair to say that the jurisdiction to pass laws with respect to health is mixed. And the Supreme Court of Canada has referred in one case to the fact that it's an amorphous area, meaning sometimes it's hard to tell who has the power to pass a particular law and where it falls. But I think it's also fair to say much of the power to pass laws in the area of healthcare fall to the provinces and territories, though the federal government does have a valid role. And in many instances, both federal and provincial governments can legislate in the same area. So for example, if we used quarantine or that a person needs to stay, for example, removed from other persons because they're suspected of having a certain infectious disease, you'll see we've got federal laws of quarantine. I mentioned our Federal Quarantine Act, for example. And that initial version of that act was, I think it does go back to shortly after the time of Confederation. And you can imagine at the time, the big concern federally would be the importation, for example, of infectious disease on ships that docked into ports coming into Canada, and so on and so forth. We've also got, though, in every piece of provincial and territorial public health legislation, laws on quarantine for how to deal with quarantine within a province. So this is an example of an area where both federal governments and provincial governments have a very legitimate role to play on quarantining persons with infectious disease. And the distinction will be, what do they govern? So if we're thinking of the federal government, we're often thinking about coming in through borders, controls taken at airports, those kinds of things, versus provincial powers, which deal more directly with people within a particular province or territory and how we can quarantine them. But essentially, if a law is challenged based on this Constitution Act of 1867, in other words, I'm going to challenge this law because I don't believe the federal government had the proper authority to pass it, courts will examine whether that's the case or not, and may uphold the law or may strike it down as unconstitutional. And the second main, I think it's fair to say, way that a law or an order under a law could be challenged under our Constitution is under our Charter of Rights and Freedoms, which came into effect in 1982, so much more recently. And everyone has heard of this, and everyone has heard of a number of the rights and freedoms set out in our charter. I've just listed a few examples here that are particularly relevant to our current public health emergency and some of the measures that we've been seeing taken around the world. And we see governments taking measures to limit assembly, even peaceful assemblies, to limit associations of people, so limiting the numbers of people that can get together to protect this or to prevent the spread of disease. We've seen an effect on mobility rights. For example, the inability to travel as we could have before. We've seen restrictions on other liberties, and in some cases, people being detained. So it's important, though, to know that just because law or some action taken under a law might breach a charter right, that in Canada, it is justifiable in some circumstances to do so. When we look back, if we're doing a legal analysis, to Section 1 of our Charter of Rights and Freedoms, which I've set out here, which says the rights and freedoms are guaranteed, but only subject to reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And if a law is challenged as breaching a freedom or right, and then if an analysis occurs as to whether Section 7 actually says the breach is okay, this is what I've got here on this slide, the Oakes test, is what a court will use to examine whether or not the breach is justifiable. So the first question that a court would put their mind to is the governmental action directed at a pressing or substantial concern? So for example, if they were examining a treatment order with respect to a person not following public health advice or the advice of a treating physician, for example, they would ask themselves, is the ability to issue an order like that aimed at a pressing concern? In this case, for example, the containment of the spread of a dangerous infectious disease to protect others. The second question a court would ask is the goal of the law or action rationally connected to the limitation imposed on an individual's rights? So for example, is the restriction of liberty by detaining someone in hospital for treatment during rationally connected to the goal of containing the spread of disease? The third question would be, does the limitation impair the individual's rights in a minimal fashion? And the fourth question, is there proportionality between the benefits of the limitation or infringement and its harmful impact? So a weighing of the harm and benefits, essentially. So now I'm going to move into a brief description of a number of the key powers and duties that public health officials have, as I've put it, quote unquote, in normal times. In other words, when we're not in the midst of a declared public health emergency. Just to set in context, when we get there, the even more extraordinary public health powers that exist after a declaration of a public health emergency under our law. So the first is the power that medical officers of health have to determine whether action is needed to protect the public health from real or suspected communicable disease or public health emergencies. So in other words, broad powers of investigation by medical officers of health, if they need to do so, to determine whether they need to take any action to contain the spread of an infectious disease. There are numerous powers, secondly, to collect information that medical officers of health have. And I haven't listed all of the sections, there's a number of them. In part, though, they can collect information to assist them with investigations. The third one I have listed there is, sounds very broad. Medical officers of health have the power to take whatever steps they consider necessary to suppress infectious disease, protect unexposed persons, break the chain of transmission, or prevent the spread of the disease, or to remove any source of infection. Next, they have specific powers to issue orders in certain instances. So a medical officer of health could issue an order to a specific person to refrain from attending school, for example, to refrain from going to their place of employment, or to have contact with any other either specified persons or classes of persons. So those are some specific powers that medical officers of health can take by order when they believe that engaging in a particular activity could transmit an infectious agent to others. Finally, on this slide, there's a power to order the decontamination or destruction of any contaminated articles that the medical officer of health reasonably suspects have been contaminated. This is a continuation of that list. Medical officers of health, even during so-called normal times, can enter any place without a warrant where the medical officer of health knows or has reason to believe that a person who has an infectious disease may be found at that place, or the place may be contaminated. They can do so to examine and determine the existence of the disease. A medical officer of health can approve a place for the quarantine or isolation of a person. And this next one relates back to my example of the active TB patient. A medical officer of health can issue a certificate with respect to a recalcitrant patient, that is, that individual who's not complying with advice and following the advice provided to help prevent the spread of disease, and essentially order them into quarantine so they can be apprehended and conveyed to a facility for testing, examination, etc., to determine whether or not they are infectious. During normal times, physicians, which would include medical officers of health, but would obviously be broader than that, not only have a power, but actually have a duty under Alberta's Public Health Act to issue an isolation order with respect to that, what we call under the Act, a recalcitrant patient. So if either a physician, in combination with a lab report, or two physicians confirm that an individual is actually infected with a specified infectious disease, that person can be subject to, and they're not cooperating, etc., they can be subject to an isolation order. And there is no discretion under our public health legislation about whether or not that order is issued, but it is person specific. So next I've got a couple of duties, corresponding duties of medical officers of health if a person is certified and must quarantine or isolated under an isolation order. And the first of those, and these are pretty onerous duties, but this is the way our legislation reads. The first of those is that the medical officer of health must ensure that the person is provided with all supplies and services necessary for the person's health and subsistence. And secondly, they must ensure that any person providing those supplies or services under this section takes adequate precautions to avoid contracting the disease. This next list is specific to executive officers, those public health officials that I said weren't necessarily physicians, like medical officers of health, but are empowered to do certain things under the Act, though they would include all medical officers of health. And the first thing to note is that these executive officers, including medical officers of health, had broad powers to inspect public places for what the Act calls nuisance. And a nuisance is, by the way, a condition that is or that might become injurious or dangerous to the public health, or that might hinder in any manner the prevention or suppression of disease. So if a medical officer of health thinks there is a nuisance, or they're concerned about whether the Act is being complied with, they've got broad powers of inspection with respect to public places. Now, if we didn't see what public places included, we might not think that was so broad. But below, I've set out in the second bullet point here the definition that our Alberta Public Health Act sets out as to what is a public place, what does it include? And it's a very long list, a very large and inclusive list of places. It includes any place in which the public has an interest arising out of the need to safeguard the public health, and includes without limitation. So this is a list, but not an exhaustive list. Things such as public conveyances and stations, terminals. So that could be airports, it could be bus stations. Places of business, learning institutions. And note that isn't just schools or post-secondary institutes, but that's much more broadly construed. Places of entertainment or amusement, places of assembly, dining facilities and licensed premises, accommodation facilities, including all rental accommodations, recreational facilities, medical, health, personal and social care facilities, and any other building, structure, or place visited by or accessible to the public. So public places, as I say, very broadly defined, and there are broad powers of inspection of public places. There are also powers, much more limited powers, but powers do exist for executive officers to inspect private places, including private dwellings, if certain criteria are met. In under another section of our Act, broad powers to issue a large range of orders to address any type of nuisance or breach of the Act that is determined. And again, during normal times, and this is our last normal times one, our Chief Medical Officer of Health of the province, she would of course have all of the powers that medical officers of health, other medical officers of health or executive officers have. But in addition to all of those other powers, our Chief Medical Officer of Health of the province in normal times has these couple of extra powers. She has the power to give directions to our Regional Health Authority, Alberta Health Services, and to medical officers of health and executive officers in the exercise of their powers and the carrying out of their responsibilities under the Public Health Act. And for example, she has powers under our communicable diseases regulation that are disease specific. For example, she can specify quarantine and isolation protocols that must be followed if an individual is quarantined or isolated for a listed disease. And she's got the power to delegate in writing any of her powers, duties, and functions to Department of Health employees. So that's not a complete list, but that's a list of the most significant powers during normal times that our public health officials have. And you can see they're quite vast. And hopefully that gives you some idea of why we have limits on those powers and the expectation that the powers only be used when necessary. The next thing I'm going to touch on before jumping into the public health emergency scenario is some particular powers our Alberta's Public Health Act sets out during an epidemic. So as I mentioned, an epidemic is higher than usual numbers of a particular infectious disease. For example, in Alberta, it would not necessarily need to be on a global scale like a pandemic. But I note them because they could be used in times of pandemic as well. There's a duty in the first case of a medical officer of health to immediately inform the Minister of Health if a disease is epidemic, and that hospital facilities in the area are inadequate to provide the necessary isolation or quarantine facilities. There is a power of cabinet during an epidemic to order a hospital or the owner of facility being defined as any place a person can receive treatment for the disease, to provide isolation or quarantine in the amount and manner described. And there is a corresponding duty if cabinet were to order not a hospital, but a facility to provide such isolation or quarantine premises for the Crown to assume responsibility for any reasonable expenses incurred. So a corresponding duty if such an order is made. So now we jump into what powers exist during a public health emergency. So this first slide talks about our medical officers of health. And essentially they would have all of the powers that they have during quote unquote normal times. The additional power that they would have during a public health emergency is that they may require a person to provide any information requested by them, as long as they set it out in a written notice, to either themselves or an executive officer or community health nurse that they designate, to assist them in carrying out their duties or exercising their powers under a particular section of the Public Health Act. And it has to be with respect to the public health emergency. So that is an extra power added on during times of public health emergency for medical officers of health. There is an additional power of our Chief Medical Officer of Health if we're in the midst of a pandemic influenza public health emergency. And that is that she may, subject to the terms and conditions she imposes, authorize the absence of specified persons who are ill with pandemic influenza or who are caring for a family member who is ill with pandemic influenza from employment. So next, how do we get into a state of public health emergency? Who has the power to declare such a state of public health emergency? And this slide is focusing on Cabinet, LGIC. The Act will refer to the Lieutenant Governor and Council. And of course, the Lieutenant Governor is an important aspect of this, but it's essentially a Cabinet power. And Cabinet has the power to declare a public health emergency, which in part is defined as an occurrence or threat of an epidemic or pandemic disease that poses a significant risk to the public health. So they can declare such an emergency where, on the advice of our Chief Medical Officer of Health, Cabinet is satisfied that a public health emergency exists or may exist, and prompt coordination of action or special regulation of persons or property is required in order to protect the public health. Just a quick note about our Regional Health Authority, Alberta Health Services. The Act also provides that they can declare a public health emergency under similar criteria. But if Alberta Health Services had declared a public health emergency prior to March 17th, when the government did, once the Lieutenant Governor and Council, the Cabinet declaration has been made, the Regional Health Authority declaration essentially disappears. So they're not both in force at the same time. Now, the Public Health Act provides some checks and balances or some safeguards with respect to a declaration. And this would be some of those things that a court would examine if they were, for example, considering the Oakes test that I referenced, if they were considering, well, was such a declaration constitutional, for example. In addition to the criteria that must be met, which I've already set out, the declaration is time limited. And when does it lapse or when does it end? It ends at the earliest of 30 days. So you declare and 30 days goes by and it lapses, or 90 days if the declaration is made with respect to a significant likelihood of pandemic influenza. So of note is that the current declaration that was made by Cabinet was based on advice not only from our Chief Medical Officer of Health that there was a public health emergency, but on her advice that we had a significant likelihood of pandemic influenza. So as a result, if you take a look at that declaration that was made, it states it is in force for 90 days, unless it ends sooner than that. So 90 days in this case, or sooner if the order is terminated by Cabinet. So just as they can initiate such a state of emergency, they can end it. And the Act imposes a duty on them to end it when they consider the emergency no longer exists based on the advice, again, of the Chief Medical Officer of Health. What happens if we get to the end of that 90 days and the public health emergency, in the opinion of the Chief Medical Officer of Health or others, still exists? It may be continued beyond that, but only by a resolution of the Legislative Assembly. So it would go back to the Legislative Assembly for a determination as to whether it should be further extended or not. So now I'm moving into extra, so to speak, extra powers that exist during a public health emergency. And Cabinet has some extra powers under our Public Health Act during a public health emergency. The first is that Cabinet can order the closure of any public place. And again, just a reminder that we looked at that definition of public place. It's very broadly defined and includes many, many places across the province. They can order the postponement of an intended election, but for not more than 3 months, and this is subject to some other Alberta legislation. And they can order the immunization of persons who are not currently immunized against the disease or who do not have sufficient other evidence of immunity. Now, that obviously wouldn't be used at the moment. We don't have a vaccine for COVID-19, but if we did, that would be a possible power of Cabinet to order the immunization of persons. Our Minister of Health has some specific additional powers during a public health emergency. And these powers are there. The Act states for the purpose of preventing, combating, or alleviating the effects of the public health emergency and protecting public health. So what are the 5 things that the Minister of Health can do? Well, the Minister of Health can acquire or use any real or personal property. Real property being land, personal property being things you can, like cars, books, other types of property that aren't land, basically. So a Minister of Health could say, for example, we need to use your real or personal property, your hotel, for example, perhaps for a quarantine facility, etc. And the Minister of Health would have the power, if needed, to make that happen. If the Minister of Health uses that power, there is a corresponding duty in that case to reasonably compensate the owner of the real or personal property. And the Act goes into some more detail about that. The Minister of Health can also authorize or require any qualified person to render aid of a type the person is qualified to provide. The Minister can authorize the conscription of persons needed to meet the emergency, can authorize the entry into any building or on any land without warrant by any person, and can provide for the distribution of essential health and medical supplies and provide, maintain, and coordinate the delivery of health services. So quite significant powers that the Minister of Health has during a public health emergency. What about other ministers during emergencies such as this? Now, you'll note that I've got 2 bullets, and one I'm talking about before Bill 10, and the other I'm talking about after Bill 10. For those of you that may not have heard, government did introduce 4 bills at the end of March that my understanding is related to the pandemic. One of those bills, Bill 10, made amendments to our Public Health Act. It had first reading on March 31st, and it came into force April 2nd. With some of those sections retroactively effective to March 17th, the date that the public health emergency was declared, and one of those sections coming into force retroactively to March 27th. So just a quick note that if you do want to take a look at what our Public Health Act says today, you could go to Alberta Queen's Printer and you could pull up the Public Health Act on that government website. But you'd also want to take a look at Bill 10, and you'd also want to take a look at some of the ministerial orders that have been made that I'm about to reference now. But before Bill 10, before amendments were made in early April to our Public Health Act, ministers responsible for certain pieces of legislation had the power during a public health emergency to, by order, suspend or modify the application or operation of all or part of an enactment, enactment being an act, a regulation, an order made under an act regulation, for example, without consultation, subject to the terms and conditions they prescribe, if that minister is satisfied that its application may directly or indirectly unreasonably hinder or delay action required in order to protect the public health. So significant powers that would be unusual during normal times in a free and democratic society to suspend the application or operation of certain parts of the law if they felt that it needed to be done to protect the public health. After the amendments made in Bill 10, in addition to being able to suspend or modify the application or operation of an enactment, a minister responsible for a particular enactment can, in addition, specify or set out provisions that apply in addition to or instead of any provision in enactment, if the minister is satisfied that doing so is in the public interest. So the criteria has changed a little bit as well. And Bill 10 said that these orders may be made retroactive to the date of the declaration of the public health emergency, March 17th. The limitations that were placed on it were that the order cannot impose or increase any tax, appropriate public revenue, create a new offense with retroactive effect. So there were some limitations made there within the amendments. There are corresponding duties, publication duties, with respect to some of these orders I've been talking about during a public health emergency. So technically speaking, under the Act, the Minister of Health has the duty to publish the declaration of a public health emergency, or to publish cabinet orders authorizing ministers, in the case of a significant likelihood of pandemic influenza, to suspend, modify, etc. laws. Or a minister who actually makes one of these orders to suspend or modify the application of enactment, or now add to, etc., an enactment, has the responsibility to publish details of that. In a few slides, you'll see I've got a link to the government site that lists a lot of great information about the current situation, but includes a link directly to the legislation and orders. And it's a great resource for Albertans if they want to take a look at the work that government has been doing on this front. It's great that government has put it all in one place and made it easily accessible instead of spreading it around amongst ministries, etc. So quickly, when do these ministerial orders, if made, and a number of them have been made, when do they come to an end? So essentially they come to an end, whichever comes first, either 60 days after the declaration of the public health emergency lapses, or when the order is terminated by the minister who made it, and they've got a duty to terminate it if they're satisfied it's no longer in the public interest, or when the order is terminated by cabinet. So of those three things, whatever happens first is when the order comes to an end, unless cabinet continues the order. And cabinet has the authority to continue an order up to 180 days maximum beyond the end of the public health emergency. Important, I think, to briefly note the protection from liability that certain persons have under the Act, if they're taking actions under the Act, both in normal times and during a public health emergency. So this is certain limited protection. It's protection from an action for damages being commenced against you. So somebody, for example, going to court and filing a civil claim for monetary compensation because you harmed them. So in normal times, specified persons, for example, the Crown, the Minister, Alberta Health Services, medical officers of health, executive officers, health practitioners, have always have this protection from liability for anything they do or don't do in good faith while carrying out their duties or exercising their related powers. In a public health emergency, that protection can be extended and is extended to any person or organization who acts under the direction of the Crown, the Chief Medical Officer of Health, or a medical officer of health related to the public health emergency. So one of the ministerial orders that has been issued, at least one of the ministerial orders that has been issued during this particular public health emergency, with respect to setting up quarantine isolation space and services in Calgary for people that are homeless, in part provided protection, directed an organization to provide such services, to provide them with this protection, which I think is very appropriate. And essentially, lastly, this slide just provides that link I mentioned, where government has very clearly set out all of the things that they've been doing. And this is just a bit of a summary of that. As I mentioned, there are 4 bills that are related, one being the Bill 10 that I referenced with changes to our Public Health Act. There have been, at least when I checked this morning, 3 orders in council, including the declaration of the public health emergency that are listed there. There are numerous ministerial orders, I believe 31 at the moment, including 2 enforced ministerial orders with respect to amendments to the Public Health Act, and numerous orders of the Chief Medical Officer of Health I believe 7 are currently in force with a number of exemptions and clarifications. So it's an indication of the massive amount of work that's been done by government and public health officials to address numerous issues, to make changes, to rescind things as they see that it's needed, or to respond, I'm presuming, to feedback that they received. So for example, in one of the orders issued by our Chief Medical Officer of Health relating to isolation and quarantine of persons, the effect of it, and I'm sure the unintended effect of it, was if a child needed to be, for example, admitted to hospital and a parent had the obligation or duty to self-isolate or quarantine, they would not be able to accompany that child. There's now some revised advice and a carve-out, an exemption to that, to allow a parent to attend, for example, a hospital with a minor child, and a number of rules set out that they must follow to, again, try to mitigate the spread of any potential spread of any disease. Another key example would be orders of the Medical Officer of Health with respect to operational standards for healthcare facilities, including nursing homes, long-term care centers, etc. So if you take a look at this, it's a lot of work and a lot of effort in terms of addressing many aspects of this public health emergency. On the negative side, the rapid pace of change is hard to keep up with. It's hard to determine, in some instances, likely for people what are the current rules of the day. On a very positive side, it's clearly a huge attempt to respond to issues, to make corrections as needed, to take into account feedback that's provided. So I'm not going to cover everything that I had here initially. I think I've been talking too long, and it's time to get to some questions and discussion. But I will just say that currently, governments, public health officials, healthcare workers, etc., have been addressing and dealing with this public health emergency, I think largely, well, in a cooperative, positive way. We're polite Albertan Canadians who mostly care about our neighbors, and I think are generally following the advice, unlike in other instances elsewhere in the world, in some examples. And I think at the moment, this isn't the right time to critique or examine very closely the steps that have been taken. But perhaps when the dust settles, it would be a good time to reflect on the powers that exist, the use of those powers, and which is partly what these public ethics talks that the DOSTER is supporting are intended to do, to encourage some reflection, some ethical reflection on the pandemic and related issues. So for now, thanks for your attention, and I'm happy to try to take your questions or hear your thoughts or any feedback on that talk. So thank you.